My name is David Stras, and I currently serve on the Minnesota Supreme Court. In fact, I just went through an election last week, so I'll continue to serve for another 6 years. And I was appointed by Governor Tim Pawlenty in 2010 to the court. Before that, I was a law professor. So when the Federalist Society asked me to come and moderate panels or to participate in events like this, it's an easy call for me because I enjoy the robust debate that the Federalist Society provides. They do a terrific job, and this panel is absolutely no exception. I have been really interested. Some of the panelists sent along some readings for me, and I've had an opportunity to look at them. I am convinced we're going to have a very interesting discussion, a very robust discussion, and so I very much look forward to hearing what they have to say. The way we're going to work, we only have one person on sort of the pro-national popular vote side, which is Dr. John Koza, and he's going to start out by laying out the national popular vote plan. And then we're going to have a series of responses among the other panelists. And then we'll open it up for questions towards the end of the program. So our first panelist is Dr. John Koza. Dr. Koza received his PhD in computer science from the University of Michigan in 1972. From 1973 through 1987, he was co-founder, chairman, and CEO of Scientific Games, Inc., where he co-invented the rub-off instant lottery ticket used by state lotteries. Between 1988 and 2003, he taught a course on genetic algorithms and genetic programming, and he's also been a consulting professor at Stanford. But most importantly, he is the leading author and the chairman of a group urging state legislatures to adopt the National Popular Vote Plan. And his book is Every Vote Equal, a state-based plan for electing the president by national popular vote. So without further ado, I turn it over to Dr. Koza.
Well, thank you for the introduction, and to the Federalist Society for inviting me to the panel today to discuss the National Popular Vote Bill. The National Popular Vote Bill would guarantee the presidency to the candidate who gets the most popular votes in all 50 states and the District of Columbia. And the bill addresses the three big shortcomings that we find in the current system of electing the president. All three shortcomings stem from state statutes, the so-called winner-take-all statutes, which award all of a state's electoral votes to the presidential candidate who gets the most popular votes inside that state. And one of the consequences of the winner-take-all rule is that in 4 of our 57 presidential elections, a second-place candidate has won the presidency. We've also had numerous near misses, particularly in the last 7 elections, where we've had 7 consecutive non-landslide elections. So we shouldn't be too surprised that the 1 in 14 overall chance of a second-place president, which translates into a 1 in 7 chance for non-landslide elections, we shouldn't be too surprised that we had one second-place winner in the last 7 elections. And if the current political polarization of the country continues, we certainly can expect more. The more serious problem of the winner-take-all rule is its effect on presidential campaigns and then presidential governance after a candidate is elected. So we just went through an election where 41 of the 50 states were effectively ignored by the presidential candidates. And the reason is the winner-take-all rule. If you're safely ahead or hopelessly behind in a particular state, there's no reason to pay attention to the state or the issues that are relevant to the people of that state. What matters is what's happening in the 9 swing states, where after the conventions, the candidates concentrated exclusively their campaigning time and their extensive advertising campaigns. These campaigns have to do with both politics and governance. 2001, we saw the free trade president from the Free Trade Party come out for steel quotas. Remarkable. But if you think of the battleground states at the time of Pennsylvania, Ohio, not so remarkable. Recently, we saw in the stimulus bill from President Obama funding for the train to nowhere between Tampa and Orlando, high-speed rail to go a few miles. Whereas in fact, and I took it last night, there's a rail line that works in this country. I call it the Spectator State Special. Amtrak calls it the Excella, and it goes from DC to Maryland, to Delaware, to Pennsylvania, which is now an irrelevant state in presidential elections, through New Jersey, New York, Connecticut, Rhode Island, and Massachusetts, none of which make any difference if you're running for president. And there's numerous other examples, everything from the Small Business Administration's largest loan ever to a Ricotta cheese factory in guess where, Ohio. Oh, and maybe I forgot to mention the auto bailout. The fact is that 2/3 of the campaign events and 2/3 of the money, and they go in lockstep, went into just 3 states in the last election. So while there were 9 swing states that mattered and 41 states that didn't, 2/3 of the activity went into FLOVA of Florida, Ohio, and Virginia. And we think there's something fundamentally wrong with that. Ari Fleischer put it very nicely. He said if people don't like it, they can move from a safe state to a swing state. But we think there's a better solution. And the solution comes from the Constitution, where Article 2 gives the state legislatures the power to award their electoral votes in any manner they direct. So the National Popular Vote Bill is a piece of state legislation. It's an interstate compact. What it says, Vermont was one of the states that passed it recently. Vermont will give its 3 electoral votes to the presidential candidate who gets the most popular votes in all 50 states, plus the District of Columbia. But this compact does not go into effect until states having a majority of the electoral votes, that is 270 out of 538, pass the identical piece of legislation. So the effect of this legislation when it comes into effect, hopefully by 2016, will be that every voter in every state will be politically relevant in every single presidential election. And we'll get away from the system that we've seen getting worse and worse, where 4 out of 5 Americans are effectively left out of the presidential campaign. Thank you very much.
Thank you, Dr. Koza. I'm pleased to introduce our next speaker, Tara Ross, who serves with me on the litigation practice group. So I've enjoyed getting to know her through that. She's the author of Enlightened Democracy, The Case for the Electoral College, and co-author of Under God, George Washington, and the Question of Church and State. She will release a second version of Enlightened Democracy, and you may already have it. It was released in September of 2012. As a lawyer and writer, Tara focuses on the intersection among law, public policy, and constitutional history. Her work has been published in many law reviews and many newspapers around the country, and she's here to present the case against the national popular vote. And based on what she's written, I think she has some interesting things to say. Please do.
Sorry, all the banging around is my iPhone, iPad, all the stuff that's up here. So I keep track of myself. Sorry about the first editions on your table. Those are the ones that are still free. The second edition is, of course, available for purchase, but this one is still great for the history of the system and why we have it, which is, of course, what we're really discussing today. I want to say thank you to the Federalist Society for hosting this topic. It's a really important one, and I know you guys had so many different topics to choose from, but I think it's a really good thing to be discussing this. If our presidential election system is going to be changed, then we need to all know the arguments for and against that and make sure that we are involved. So you've just heard John describe his system, and he describes it as something that is not eliminating the Electoral College, but that is just using constitutional provisions in kind of a different way. I disagree. We are changing If this passes, we are changing our presidential election process from a democratic Federalist system approved by the founders at the Constitutional Convention to a purely democratic presidential election process rejected by the founders at the convention. I would suggest that if we want to make such a radical change to our Constitution, we should use the Article 5 amendment process. Now, I would be against any option to get rid of the Electoral College, but this one has some special problems of its own. So I'm going to do a brief overview real quick of why we have an Electoral College, why I think it's still important to us today, and then I'm going to touch a little bit on why I think NPV is especially problematic, and then I'm sure there'll be way more in the Q&A for us to discuss later. Something we need to remember when we're talking about the Electoral College is that the founders were not trying to create a pure democracy. That was not in their brains, okay? They knew the history of pure democracies. They knew that as a matter of history, pure democracies implode, okay? If 51% of the people can tell the other 49% what they're going to do, then that's a recipe for tyranny, for majority tyranny of the other 49%. And they knew that historically that had been a problem. But you know, the founders had a bit of a dilemma, okay? What are we going to do? We just fought this whole revolution over the concept of self-governance. We want to be a self-governing nation. We may not want pure democracy, but some democracy is important to us. So what they did is they solved their problem by creating a constitution that has some elements of democracy, small d, self-governance. It has some elements of republicanism, small r. We want to encourage deliberation and compromise in government proceedings. We want to have federalism. That's another element that they incorporated. The ability of states to act as states or on behalf of their own citizens. And so they took all of these different elements and they put them together in the Constitution, and that's why we have checks and balances, separation of powers, supermajority requirements to amend the Constitution, presidential vetoes. All of these things are checks on pure democracy that are meant to protect our freedom. The Electoral College is simply one of these. Now, the Electoral College, real quickly, the best way to think of how it works is in this country, we have a two-part election system. We're actually only partway through this presidential election cycle, even though much of this room is mourning what happened in that phase. It's only halfway over. The first phase is 51 purely democratic elections that were held on November 6th. We held 51 purely democratic elections, one in each state and one in the District of Columbia. Now, the purpose of these elections is to determine who is going to represent each state in phase 2 of the election. Phase 2 is a federalist process. It is an election among the states as represented by their state's electors. There are 538 individuals. These are actual people that are going to go to their state's capitals or other designated locations and cast the ballots that the Constitution says will determine who our president is going to be. And then, of course, it takes a majority to win. And I'm sure Barack Obama's electors will be faithful to him, and he will end up winning that election. But that election has not occurred yet. Now, the reason we have this two-part election cycle is because it protects us by encouraging presidential candidates to build national coalitions of voters, okay? You cannot win the presidency in this country unless you can win multiple simultaneous states' victories in many different parts of the country, different regions, different states, different special interests, different size states. If you can't win among a variety of voters, which Mitt Romney failed to do, if you can't do that, then you can't win the presidency. Barack Obama simply did a better job of that on November 6th. And so, sorry, I got a screensaver. So that the national coalitions is really what the presidential candidates are incentivized to do because of the process that we have, because of this two-phase election. Another thing that is encouraged is moderation and compromise, okay? We make fun of candidates who run to the middle, after the primaries, but what that's really about is that we have a system that encourages candidates, encourages political parties to focus on similarities, on the things that bring us together as Americans, not on differences. Now, we are living in a closely divided time. All that really means is that nobody's really doing a good job of it right now, and they need to get their act together and start doing a better job. We had a similar period of time in the late 1800s. I would suggest that the Electoral College during that time actually helped us to get out of that period because nobody could win, nobody could count on victory unless they reached out to voters who were not like themselves, unless they focused on what brought us together, the similarities we have as Americans. Finally, stability and certainty is something else that I think is brought to us by this election process. I lost count of how many radio stations talking about there's going to be an electoral college tie. I'm sure you guys heard this, all the moaning and groaning, and I knew it wasn't going to happen. I mean, the chances of it happening were so small, because historically, what the Electoral College has done for us, it has given us stability. It does inflate the margin of victory in a popular vote, so the electoral victory is much bigger. That's good. It means that we know who our president is. We know who the majority of citizens, as represented by their states, wants to be president. It also makes fraud harder, because you have to be able to predict in advance where stolen votes will matter, okay? Nobody knew in 2000 that 500 whatever stolen votes in Florida would change the outcome of an election. Nobody knew that. If they told you that, they knew they were lying. Now, contrast that with this, now pretend like you can imagine, you think you know. Then everybody else knows too. In Ohio in 2004, people suspected that would be the swing state that really just decided the outcome, and that did provide the appropriate margin. But look, everybody knew, and everybody descended on the state. And so instead of trying to protect our country everywhere, every precinct, the bluest of blue, the reddest of red precincts, you're just narrowing your focus down to one danger spot, danger zone, and everybody focuses and everybody tries. That is easier. I would love to prevent all fraud. That's not going to happen, but we can make it as difficult as humanly possible. So I will run real quick through some problems that I think NPV has in particular, and then I know we will get to more of it later. Look, there's lots of logistical problems created by what John has proposed here. Basically, what he's proposing is that we leave the current system in place, and then we pretend like it is possible to come up with one national vote total from these 51 different processes. Now remember, I said we have 51 purely democratic elections in this country every year. That's 51 sets of election laws. That's 51 different ways to get on the ballot. That's 51 rules about early voting. That's 51 different rules about felons. That's, name whatever it is. There's a whole slew of issues, 51 different ideas of what that should look like. And we're going to take these 51 different processes, and we're going to pretend like it's possible to come up with one coherent answer as to what the national popular vote total is. It's not going to happen. What's going to happen is somebody in Connecticut is going to file a lawsuit if they can figure out which court is the appropriate venue, and they're going to file a lawsuit. And it's going to say, I didn't get as much time to early vote as that person in Massachusetts. That's not fair. I want, this is violating my constitutional rights. And there will be lawsuits, and there will be chaos. What happens when we need a recount? And there are 51 different standards for how to conduct that recount. You thought some different standards in a couple of Florida counties was a problem? Wait until that's nationwide. That's a big, huge problem. You're going to end up with situations where you're going to have states who know that this is the way things go. You're going to see a race to the bottom as people change their laws. They're not going to want to get left out of a recount. They're not going to want their voters to get less time to early vote than other places. They're not going to want any of this stuff. You're going to have a race to the bottom to see who can have the most lenient rules possible in their state, so their state will have the biggest sway in the national total. You're going to have states that are going to hop in and out of the compact based on whether it's good for them that year. Okay? Massachusetts, I like to use that example. They change their Senate rules all the time about their U.S. senator. Do you think they want to give their electors to Marco Rubio in 2016? If they see the writing on the wall, they'll be out of there. What if Rick Perry is still governor of Texas and he's in the race and he says, no, I think I'm going to call Texas into a special session. We're going to implement this NPV business. I like it, So it's just, there are so many different political problems when you create a system like that. I think I'm running out of time. Kind of lost track, but there are lots of legal problems that I think John might touch on more than I had time to, but just to run through the headlines, does NPV's interstate compact require congressional approval? There's a lawsuit waiting to happen. Is the state legislature's plenary power to appoint electors really without limit? Unclear. Can an interstate compact be used to bypass Article 5 amendment process, or will precedents such as U.S. term limits in Clinton versus New York cause it to be struck down as an unconstitutional end run? I would suggest it might be. Either way, litigation is inevitable, and it would be much easier just to have a dialogue as provided for in the Constitution in Article 5. Thank you.
Thank you, Tara. Dr. Koza, would you like to take a few minutes to respond to some of the critiques of the National Popular Vote Plan?
Yes, thank you very much, Mr. Justice. First of all, Tara said that the current system was approved by the founders at the convention. The winner-take-all rule was never debated at the convention. It was used by only 3 states in 1789. It's not in the Federalist Papers. The founders were dead for decades before the winner-take-all rule became prominent. So it never had the imprimatur of the Constitutional Convention, which envisioned a deliberative electoral college, not a political party driven electoral college where we have rubber stamp electors. She mentioned that national popular vote was rejected at the Constitutional Convention. I guess they got an advance copy of the book. In fact, that's true. Direct election was voted down. But on June 2nd, 1787, election of the president by electors chosen by voters of the states by district was voted down. That was used by 2 states in the first election. Election by the state legislatures was voted down by the Constitutional Convention, used by about 5 or 6 states in the first election. And in fact, appointment by the governors was voted down, and that was used by 1 state. In fact, in the first 7 presidential elections, all 3 of those methods, rejected specifically by the Constitutional Convention, provided a majority of the electoral votes, apparently electing the first 7 presidents unconstitutionally. Tara says that NPV would lead to a democracy. Not true. Look at Federalist 10 and 14. There's a specific definition of democracy, the same one that I remember and you probably remember from high school, about people electing officials who exercise governmental powers for a particular period in lieu of direct democracy. So we do not install direct democracy at all. The United States is a republic. It will remain a republic under the national popular vote. Election of the chief executive of government does not determine whether the government is a republic. In fact, 4 states elected their governor in 1789 by the people. Now, those 4 states certainly were not in violation of the guarantee clause of the Constitution, and certainly did not think that they were doing something that was contrary to the principle that the United States is a republic, not a democracy. In terms of federalism, we're talking here about the size of the district used to elect presidential electors. Right now, it's statewide in 48 states. It's district-wide in 2 states, and we're proposing a nationwide district. But the district size has nothing to do with, to quote Tara, the ability of states to act as states on behalf of their citizens, has nothing to do with governmental power, has to do with what size district and which shape district is going to pick presidential electors. So federalism has to do with power of state governments relative to the national government, and we do not accept that. She says the current system encourages national coalitions. Well, I don't know what her definition of national coalition is, but Nevada, Colorado, Iowa, Wisconsin, Ohio, Virginia, North Carolina, Florida, New Hampshire, that's a national coalition. What about the other 41 states? Moderation. Moderation is not affected by whether you elect the chief executive by direct popular election. We've had 5,000 elections for governor. How many extremist governors have we seen? And as for stability and certainty of outcome, we've had only 57 presidential elections, but we've had 5 litigated state counts. Now compare that to what happens in normal elections, of which there were 425 statewide elections on the ballot 2 weeks ago in this country. As of yet, there's not 1 recount. There'll probably be 3. There's 3 in the making. The long-term historical odds of a recount is 1 in 160 elections. So compare the chance of a recount in a normal, straightforward popular vote, 1 in 160, with our actual experience of 5 litigated state counts in 57 presidential elections. I would say the current winner-take-all system is not a firewall that prevents fires. It's something that creates unnecessary fires when there's no reason to have a dispute at all. Fraud, we can't predict in advance which states will matter. Well, I remember an article by Karl Rove in in the Wall Street Journal in June called My 3-2-1 Plan for Romney Winning. And he listed the 6 states that Romney ought to concentrate on and use to win. I don't think there was any mystery about where fraud would matter. It certainly didn't matter in Kansas this year. It could well have mattered in Ohio or Florida or Virginia, where those candidates spent 2/3 of their time. Logistical problems. Quote, pretend it's possible to come up with our national vote total. Well, Congress has required for over 100 years a certificate of ascertainment that has the popular vote count and the electoral vote count. The National Archives has a spreadsheet for each recent election of the popular vote taken off those official counts, and you can add them up. I don't see why it's difficult to pretend it's possible to come up with a national vote total. I think it takes a calculator. One coherent answer? Yes, there is a coherent answer. It's the sum of the 51 numbers. Lawsuits. The lawsuit in Connecticut, they didn't have enough time to early vote. Sounds like sort of an interstate 14th Amendment. And by the way, you'll notice the National Popular Vote Plan, if you look at our book, is founded on actual words in the Constitution and actual U.S. Supreme Court cases, not cases we wish we had. So let's talk about the Connecticut voter or being unhappy, say that they got less time to early vote. Probably did affect the outcome. The Connecticut vote, based on, let's say they have ungenerous early voting, maybe was somewhat more difficult than an Ohio early vote, which had fairly generous hours for early voting. 14th Amendment is in effect today. We could have that lawsuit now. Connecticut's electoral votes are added to and commingled with Ohio's, and Ohio's are the ones that determine the outcome. So could there be litigation? Yes, you could if there was a filing fee paid, but could you have successful litigation based on this interstate 14th Amendment concept that has no judicial precedent? I think not, but if there could, we could have it today under the current system. She talks about people coming in and out of the compact. Well, you have to get to 270 electoral votes by July 20th. On July 20th, the polls showed in Nate Silver's column that Romney was ahead in the popular vote and behind in all the swing states that actually determined the presidency. But all those numbers had a margin of error of 3%, which, by the way, is almost the definition of a battleground state. So I don't know how you could, prior to July 20th, decide what the outcome of the November election is long before the convention with the empty chair, long before the botched presidential campaign debate by the incumbent who apparently didn't want to practice, long before the vice president was chosen. The fact is, if you want to be in this compact, fine, but you're not going to come in and out just before July 20th on the basis of polls which have a margin of error bigger than the number of votes that are being fought for. Tara talks about congressional consent. Well, we like what the Supreme Court decided in 1893, that congressional consent is not required for interstate compacts if they don't threaten federal supremacy. That is the test, reinforced by Powell and Rehnquist in 1978 as part of the federalism expansion to give the states more leeway. We like that decision, and we think it applies to us because the Supreme Court has repeatedly held that the decision on how to award electoral votes is an exclusive and plenary power of the state government. So we don't think this compact requires congressional consent. We will go off and seek it because it's good politics, and congressmen are very influential, and their opinions should be respected. But in terms of a lawsuit, we think that congressional consent is not required. But if it is, if the courts tell us it is, we'll have to go get it. And many compacts, including the one in the 1978 case, actually had tried to get congressional consent and couldn't. Then they went to court, and the Supreme Court told them they didn't need it. Finally, she talks about this phrase "without limit," which she didn't have enough time to explain, but she explains in the paper in her book, whether the state's power to award electoral votes is without limit. Well, it's not without limit. There's a limit right in Article 2. There's a specific limit. You can't appoint federal office holders as presidential electors. There are other limits. You can't pass an ex post facto law, make it a crime to commit voter fraud after the election and try to put people in jail on the basis of that. There's all kinds of restraints in the Constitution. You can't exclude women from voting or 19-year-olds from voting. But aside from those specific constitutional provisions, the court has held in very strong language that it's a plenary, an exclusive power of the state to decide how to award its electoral votes. So I don't know, she keeps looking for these penumbral emanations from Article 2, and I don't seem to find them. Thank you.
Our final speaker is Dr. John Baker, who is the Distinguished Scholar in Residence at Catholic University, and he's an Emeritus Professor of Law at Louisiana State University Law School. He also teaches a number of short courses on separation of powers with Justice Antonin Scalia. I've heard it's a wonderful program. I haven't personally been able to attend, but I know that it's co-sponsored or sponsored by the Federalist Society, and I would urge you all to give it consideration in the future. And he has presented cases in a number of federal courts, including arguing before the United States Supreme Court. So without further ado, I will turn it over to Dr. Baker.
The most important thing to get across in this session is to understand how close this thing is to passing. It's under the radar. There are 9 jurisdictions that account for half of the 270 votes needed that have adopted this thing. They're all blue jurisdictions, but prominent Republicans are on board. Senator Fred Thompson, a great Federalist, is on board with this. Tom Tancredo came into our state of Louisiana to lobby for it. Had it been the case that Romney won the popular election and Obama had won the presidency by the Electoral College, we would have seen a tidal wave of Republicans supporting this. Of course, we tend to do things after the cow is out of the pasture and there's nothing you can do. And it's amazing. When I spoke on this in the state of Washington, I asked a body of law students how many knew that their state had adopted the provision. Nobody. How many knew what the provision was? Nobody. This thing is flying under the radar, and the most important thing to do, from my point of view, is to stop it before we get to the litigation phase. Because if it does get that far before the next election, we will have very complicated litigation in which the outcome is unclear. So, with that happy news, let me start and focus on 3 things. Some of this will overlap with what Tara did, but maybe I'll go into some more detail. First of all, you have to look at what's the problem and what's the proposed solution. Second, I want to focus on the actual mechanics, because if you look at the NPV's literature, you are hard put to find actually what the statute says, and I'll go through that. And the third thing is I want to talk about the Electoral College, as Tara did as well. The problem is said to be the winner-take-all result. Well, that's one problem, supposedly, and the other problem is that we need to have all votes count, and that count should reflect a majority of Americans, and that should determine the outcome. I want to deal with the question of ignoring of certain states. The provision that's being talked about is in Article 2, Section 1, the second paragraph, and it's absolutely true that the states can award their electoral votes in a way that they choose by statute, and that can vary from state to state. It has varied over time in this country, and there are currently 2 states that allow the awarding of electoral votes according to the majority in congressional districts, okay? Now, if what you're really concerned about is you're not getting to see presidential candidates in the flesh when they stop over at an airport press conference, there's an easy solution to that. change your own electoral vote. That is, California is perfectly free to adopt, for instance, awarding electoral votes based on congressional districts. And based on that, Romney would have had a shot at about 16 electoral votes in terms of congressional districts. And if California had that solution, I'm sure that Mr. Romney would have made some visits to California. Why does California not do it? The same reason most of the other states don't do it. There is a majority in that state that wants it that way. They're free to change it. They don't want to change it. They like the power they have. And they're free to do that from state to state. The real issue is not that. Because if the real issue were that, the national popular vote would be seeking a compact to enforce that on all the states. But that's not what they're seeking. They're seeking to get us a national popular vote, period, and a run around the Electoral College. The interesting thing about this, and we won't spend too much time on the cases, is that the court in two cases, one in the 19th century and one in 1978, talked about whether compacts all had to be approved by Congress. If you read the actual language in Article 1, it would appear that that should be the case. No state shall, without the consent of Congress, and I'll just go to the relevant part, enter into any agreement or compact with another state or with a foreign power or engage in war, etc. That was part of the anti-confederation element of our Constitution. They understood that we needed to get away from the Confederation and create a real government. And historically, confederations had either blown apart or they had consolidated power. Compacts allow consolidating of power. Compacts, treaties, confederations are virtually all the same. A number of states in the South, you might recall, attempted this at one point. There is power in numbers. That's what they wanted to prevent. That's why it had to be confirmed by Congress. There are two cases. The 78 case, I would have gone with the dissent in that case because it emphasizes language in the original case, the Virginia versus Tennessee case, that is ignored by the majority in the second case. And that is that originally there was a question about what kinds of compacts require what kinds of approval by Congress. There's actual approval and implied approval. We won't go into all that. But beyond that, there is the question of, in the later case, if you have a compact or an agreement that doesn't require approval, it has to be shown that it doesn't threaten federal power. But the earlier case also said it must not threaten the power of other states. And compacts do threaten the power of other states, and that's the problem for other states that don't enter into the compact itself. It is a deeply federalism issue. Paul Clement, the other day in his address, talked about the importance of the federalist aspect of the Electoral College. Now let's turn to the mechanics of this thing. I'm just going to hit a few high points here. First of all, it starts out prior to the time set by law for the meeting and the voting by presidential electors, which is coming up in December. The chief election official of each member state shall determine the number of votes for each presidential slate in each state. Do you realize that every member of the compact will make a separate determination of what the national vote is? There's not one national official doing this, although there will be calls for that. Each of the states is to make its own determination. Is it possible that elected officials in some states that are Republicans and elected officials in other states that are Democrats might come to different numbers in a close election? Is that possible? I think it's quite possible. Two, how about the withdrawal provision? Any member state may withdraw from the agreement except that a withdrawal occurring 6 months or less before the end of a president's term shall not become effective until a president or vice president shall have been qualified to serve the next term. Who's going to enforce that? Where's the mechanism to enforce that? There is no mechanism to enforce that at all. Now, it is said that this won't do away with the Electoral College. The last provision is, this agreement shall terminate if the Electoral College is abolished. Anticipating what? This is a compact, yes. It is a suicide compact because it will create such chaos that people will demand a federal control of the election. I debated this issue just a few weeks ago at Tulane with a very elegant German professor, and he said, you know, the French and the Germans think Americans are crazy. When you have a national election, why doesn't the national government control everything? Why do you have this litigation? Why do you have recounts? I said, that's federalism. He said, well, we have a different type of federalism. Yeah, we know. This is an interim step to get rid of the Electoral College through a very clever attempt at a compact, hoping that it doesn't require approval. My last point is on Electoral College. I just want to tell a little story here. Professor Nadine Stras was unable to come here, but she and I co-taught the Federalist some years ago. And when we got to the Electoral College, she told this story that her husband, who originated from Israel, came to take his citizenship test. And when he did so, he got a question wrong, he was told. And the question was, who elects the president? And he checked the Electoral College. And he was instructed by the government official, that's wrong. The people elect the president. Had he not changed his answer, he wouldn't be an American citizen today. The problem is Americans don't understand the reason for the Electoral College. Indeed, if you read the Federalist, what you will find is that in defending the presidency against all of the charges that it was creating a king, the Federalist starts out by saying the only part of the executive branch that is not criticized is the method of electing the president. They thought it a wonderful idea. Why? Why are there separate states? Why is it that there is only a single purpose for the gathering in each state? It is to prevent a national cabal. It is to prevent corruption. You'd have to corrupt a number of states. We don't have to look far around the world to see in third world countries the manipulation of presidential elections. You want to disperse the power as much as possible to avoid that kind of corruption. Some of the things that it really serves today may not have been as important back in the early days, but they're real. I've been involved in a senatorial recount, and anybody who's been involved in presidential politics understands why currently there are not more recounts. Because if you don't get within a certain small margin, the chance, given the rules on recounts and litigation, at least prior to 2000, were such that you can't overturn the results of an election very easily. And so in states where the margin isn't small enough, nobody litigates it. Well, if you want every vote to count, and you get rid of the Electoral College, we will be counting for an indefinite period of time. If you love Florida in 2000, you will love getting rid of the Electoral College. What incentive for fraud? Right now, there isn't fraud in states where it doesn't make any difference. But if every vote really does count, you pick up 100 here, 1,000 here, and you can go on and on. The election, the litigation will be in doubt. There will be no president for Inauguration Day who has been elected by anybody, because the matter will still be in the courts. One of the things the framers did was to think out consequences. Unfortunately today, people don't think about consequences. They think about abstractions. 53% of the American people, according to the latest Rasmussen poll, want to get rid of the Electoral College. They have no idea about all of these consequences. I would hope that some of you would go out there into your own states and to bring it to people's attention, not only about the Electoral College, but about the whole business of federalism. You know, in this nationalized country of ours for many years, and television and everything else, outside of Texas and a few other southern states maybe, most states don't necessarily have the kind of pride in the states that they once did. And we often sometimes say, well, you know, that's the way things have changed, and the founders, they couldn't anticipate everything. And I usually disagree when they say the founders couldn't anticipate, because they said they anticipated they couldn't anticipate. But I want to read you a quote where one of our founders, Chief Justice Marshall, really failed. This is from McCullough. "No political dreamer was ever wild enough to think of breaking down the lines which separate the states and of compounding the American people into one common mass." Oh, yeah? Thank you.
Thank you, Dr. Baker. I'll give Dr. Koza about 5 minutes to respond to Dr. Baker's comments.
Thank you very much. 51 separate determinations of the national vote. I wish Professor Baker had read down to the middle of Article 3 of the compact. He would have discovered that we adopt exactly the same formula that the Electoral Vote Act of 1880 adopted. That is the current law, federal law now, which is that the final determination by each state is binding. And that's precisely what our compact says. So that the numbers that appear on this federally required existing certificate of ascertainment, arrived at by state processes solely, is binding on all 51 secretaries of state. So there is no mechanical problem about Republican and Democratic secretaries of state having Republican calculators and Democratic calculators. Withdrawal. There is no mechanism to enforce it. My goodness, there's hundreds of interstate compacts, all of which are adverse to the individual states' interests. That's why they enter into interstate compacts. They enter into something, a contract that's adverse to their immediate interest, but when enough other parties agree to the same thing, it becomes their interest. And how do we enforce that? Well, the impairments clause of the Constitution. There are numerous cases saying no state may impair obligation of contract. It applies to interstate compacts. Most of these cases are summary judgment cases because there's really no interesting question. If a compact says that you can withdraw, but you have to give 6 months notice, then by golly, the state has to give that. I refer you to a case as recent as this July where the state of California tried to weasel out of a interstate compact, the multi-state tax compact. In fact, the same compact that's the subject of the leading 1978 case that didn't require congressional consent. And the court gives a very nice tutorial on why the impairments clause prevented California from taxing out-of-state companies to the tune of $1 billion, and that action was unconstitutional. And there's numerous other cases. In fact, there's been no case ever where a court has allowed a state to withdraw from an interstate compact in any manner other than that which they agreed to when they entered into the compact. He said this is some kind of slippery slope that's going to get rid of state control of election. Well, that would require a constitutional amendment. Not only do we not favor it, I don't know of any state that would favor that or any realistic possibility that that would ever come to pass. He says, why aren't there more recounts? There are too many recounts under the current system. There have been 5 litigated state counts in a measly 57 presidential election. We haven't even found the first recount from the 400 elections that took place 2 weeks ago at the state level. There'll probably be 3, and that'll be roughly in line with the 1 in 160. That means, in presidential terms, that we'll have a presidential recount every 640 years. And by golly, when we have that one, somebody will be very unhappy with the results. He says we'll be counting forever. Well, what about Bush versus Gore? There's a safe harbor date. The Constitution requires the Electoral College to meet on the same day across the country. Both parties, as well as the Supreme Court, and listen to the audio transcript, everybody agreed that the case had to be decided a week before the Electoral College meets, which is December 17th this year. There isn't going to be an inauguration day arrived at on January 20th without a president, because we have a Constitution that sets a very rigid, perhaps unfair to somebody who wanted to litigate forever, but a very rigid schedule that has been followed when it mattered. So there will be a president. He says, refers to the congressional consent thing. Well, let me make it clear. If congressional consent is required of this particular compact, and by the way, there will be litigation, Tara's already said publicly she's been working on it, of course there'll be litigation. There's always litigation. And the courts will tell us whether this compact needs congressional consent or it doesn't. But there's nothing novel about contracts not requiring congressional consent. Go to the Goldwater Institute's webpage. You will see a bunch of clever, very creative and clever interstate compact ideas, almost all of which are compacts that they contend, and I think correctly, by the way, do not require congressional consent. He says this threatens somehow federal power. Well, there is no federal power in this area. The choice of the method of appointing electors is strictly a state decision. Look at Article 1, where the states are given the power to conduct congressional elections. Very different. What the founders subject the states to a congressional veto over every law states pass involving congressional elections. There is no corresponding congressional oversight or veto in Article 2 concerning the state power to award presidential elector votes. As for changing to districts, just briefly, that would make a bad system worse. There's only about 41 presidentially competitive congressional districts in the country out of 435 seats. So 9 out of 10 Americans would be left out of the race for president, whereas now only 4 out of 5 Americans are left out. It would not guarantee that the candidate with the most votes wins. Particularly would not have had that effect in 2000. It doesn't make every vote equal, and it would create a system where instead of going around to 9 battleground states, the presidential candidates would go around to 40 or so battleground congressional districts. He says the laws haven't changed because the majority want it. Majority doesn't. We've taken polls in many states, usually around 75%. 66% favor a change among Utah Republicans. The public doesn't like this system. It makes no sense. It makes no sense that 4 out of 5 Americans are left out. There's a lot of reasons why laws don't change. Inertia, opposition, the delays in the legislative process, which is inherently difficult to get laws passed. But it's not because the majority supports the current system. Thank you.
Thank you, Dr. Koza. What I thought I would do is ask a question of each of the panelists and then allow the audience to get involved and ask questions as well. So if you would, let's keep this part of the program to about 3 minutes for each of the questions. So the first question is for Dr. Koza. You know, one of the things that strikes me about this plan, and it may be dealt with in the book, is we're shifting the focus of a national election from the swing states, I think, to urban areas under your plan. And the reason why I say that is if you're looking at it at the United States as a whole, a presidential candidate is going to focus on urban areas because of the concentration of population and focus less on rural areas. Because after all, it's the number of votes you get. It's not what state you get the most votes in. Is that a correct characterization? Is that wrong? And if it is correct, is this a weakness of the plan?
Well, under this plan, every voter would be equal everywhere. So a voter in a big city is no more influential or important than a voter in a small town. 15% of the population of this country lives in places over 350,000. Or to put it the other way, 85% lives in places under 350,000. So first of all, this country is not as urban as people think, but it is urban to a great degree. Those voters will count. So will rural voters. I come from California at the moment. Governors Reagan, Deukmejian, Wilson, Schwarzenegger, they never came close to carrying Los Angeles or San Francisco or Oakland or San Jose or any of a number of other California cities, yet they were elected governor. How is that possible? Because California, like the rest of the country, has all kinds of places, small, rural, medium, and large, and there was a Republican majority, as there has been to elect, Governor Romney of Massachusetts. Did he carry Boston? Or Governor Pawlenty of Minnesota. He certainly didn't carry Minneapolis, St. Paul. Or pick your other examples. So the reality is every vote would count. Sometimes I hear the argument, media costs are cheaper in the big cities. This would give the Democrats an advantage. I refer you to our book. Media costs are higher in big cities. New York, Los Angeles, about 5.5 cents per impression. Indianapolis, which is the 25th largest market, about 4 cents. Fort Smith, Arkansas, which is the 100th largest market, 3.5 cents. The reality is exactly the opposite. If media costs was the thing, the big cities are more expensive. But when it all comes to pass, it comes down to every vote is going to be equal, just as it is in governor elections. And if you want to talk politics, and you did mention politics a little, Republican governors have been elected in virtually every state. Democrats have been elected governor in virtually every state, even in Kansas, and not so far back even in Texas. So there's nothing inherently built into an election where the candidate gets the most votes that favors either party. Thank you.
Thank you. Dr. Baker wanted to briefly respond.
Well, the German professor I debated had to admit afterwards that in the German system, yes, the politicians did concentrate in the urban area.
Interesting. So the next question is for Tara. One of the things that strikes me, and Dr. Baker briefly talked about this, but this has bipartisan support, or at least some bipartisan support across the country. So I look to my native Minnesota, and I looked at the list of folks on there, and we've got Republicans and Democrats from the state house and a former U.S. senator who supports the National Popular Vote Plan. And of course, Dr. Koza mentioned, Dr. Baker mentioned Fred Thompson. And so what accounts for this bipartisan support? It's very rare when we see bipartisan support behind any initiative, national initiative.
I think there is some bipartisan support. They don't like to emphasize how many of those Republicans are getting paid. And I don't mean to imply that every single one of them is getting paid. I think some Republicans do just think it's a good idea. I think that some of them just don't understand the Electoral College, don't understand why we have it. How many people in this room learned about the Electoral College in your classes in junior high or high school? I didn't. I learned about it on my own. So I think some of it is just misunderstanding. I would also point out that MPV has tried to go in. They have gotten Republican legislators on board in states like South Dakota. And as soon as, I went in, or I think Trent England, for those of you who know him, went to South Dakota, or maybe we talked to him on the phone. I don't even remember. It blurs together sometimes. But they reversed course. Is my point. They understood the system. They understood they'd made a mistake. The sponsor of the bill in South Dakota ended up asking that his own bill be tabled, a Republican, because he understood that he had made a mistake. Okay, so what I really think the answer here is just education. It's like anything else. When you understand the system, you'll understand that it really supports us. Now, there's been some talk here today about, does this really create a national coalition, or is it really all about the swing states? Let me just point out a few things here. One is, Look, safe and swing states change all the time, okay? All the time. Virginia, North Carolina, New Hampshire, these are new swing states. West Virginia used to be really Democratic, started voting Republican in 2000 because it realized it was being ignored by the Democratic Party, okay? That's important. You cannot ignore a safe state in this country and get away with it, okay? New Hampshire, a swing state with 4 electoral votes, fantastic. Iowa, a swing state with 6 electoral votes, fantastic. You have to pay attention to everybody in this country. Another thing that I would point out is, look, a campaign is not all about the campaign stops in the final whatever weeks of the campaign. It's about 4 years of governance and what people thought of that. And there's a reason Texas is really safe red right now. It's safe red because by and large it's just really unhappy with what Obama's doing, with what Democrats are doing. They want smaller government, they want more fiscal responsibility. So California, complete opposite. You know, maybe they like the environmental things. They liked Obamacare. They liked all of this stuff. These are not states that don't matter. These are states that have already made up their minds. And if they change their minds, they will let us all know very, very fast, I promise. Even Texas and California, by the way, can change their minds. They have in the past. Both of them used to vote exactly the opposite of what they do now. And believe me, Mitt Romney or whoever's in 2016 does not want to lose Texas votes. They can't afford it because they probably can't win without us. So, I'm from Texas. So, you know, it's just, I just point out that this is all like, it's like a scare tactic. Our elections are not all about swing states. Our elections are about every single one of us, and every single one of our votes matters. And we choose to combine these democratic elections that we conduct in our states with a federalist process to make sure that the election does not turn into a big focus on urban areas. A majority of the American population, by the way, lives in the 40 largest metropolitan areas. So this is a real danger.
Thank you, Tara. My last question is for Dr. Baker. The question I have is, and this is a big theme actually throughout the book explaining the national popular vote, is that our current system is undemocratic. And one of the things they talk about, although we haven't had a situation like this, is what happens in the case of an electoral tie for president. It goes to the House of Representatives. And isn't that undemocratic? Isn't, first of all, the Electoral College undemocratic? And isn't it undemocratic to send this to the House of Representatives in the case of a tie?
Well, the Electoral College is no more undemocratic than the U.S. Senate is undemocratic. Is the federal judiciary undemocratic? We only have a partially democratic system, and it can change, and it has become more democratic over the years. But the reality is that people may well agree with Dr. Koza that the current system makes no sense. It makes no sense because, as Ted Cruz told us, there have not been enough people out there explaining the ideas. If the American people forget why we have the Federalist system we have, we won't have it. Or as Justice Scalia says, we can't save federalism if the people forget about federalism. In Federalist 39, it is explained that we have a compound system, part national, part federal. And it lists the different elements of that. And one of the 5 key elements is the Electoral College, making it a federal system. It's a mixture. We know that the Senate is less federal than it was, direct popular election. Those who are committed simply to the ideology that everything has to be most democratic aren't going to be happy until everything is one democratic mass that the founders rejected. We have to remember that our system creates multiple majorities deliberately. There is a state majority. There are majorities in congressional districts. You know, we don't have to have congressional districts in the states. They could be, you know, otherwise. They could all run statewide. There are different majorities everywhere deliberately to break down so that there is no one permanent majority and no one permanent minority. That is how we have preserved our liberty. That's what distinguishes us from other failed democracies around the world.
Thank you. I should note that I was excluding 1800 because at that point you were voting for both president and vice president, and it did end up in a tie, but the nature of the voting was a little different then. But Under our current system, we haven't had an electoral tie. So let's move to questions from the audience.
My name is Howard Lim Jr. I'm Secretary of the New York State Conservative Party, and I was a Romney elector, which simply demonstrates how irrelevant that is. Election fraud is a cancer on democracy. What the Electoral College does is it confines that cancer to the states in which that fraud is taking place. In cities like Philadelphia, New York, and Chicago, it's difficult to even get Republican elections inspectors to sit in on those polling places and make them in compliance with election law. And my question simply is, based on all the evidence that election fraud takes place in a wholesale manner in urban areas like the ones I've described to you, can anyone make the proposition that there is an equal amount of election fraud cast for both Republican conservatives and progressive Democrats? And let me finally point out that George Soros didn't spend those millions of dollars getting election clerks at the statewide level put in place because he liked clerks. He did it so he could win elections.
Does anyone want to briefly respond on the panel to that
It's not
question?
material to the topic.
Was the question whether Republicans or Democrats do it more, I think? I mean, look,
In
I think
other words, my question simply is, isn't it true that Democrats are supporting this proposition because there's a great deal more election fraud that supports their candidates and therefore helps them?
I don't like to put words in people's mouth or motivations and look, I think there's enough blame on everybody to go around for a lot of things. So I'll just say, yes, I think there are some people who like to steal elections. I'm very sorry about that. I think there are some people who know that the attention will get focused on urban areas, and they like that, fraud or not, just because there is a Democratic strength in urban areas. I think there are some Republicans who are extremely misguided, and for some reason think that this is going to be good for the Republican Party. What I would suggest is in the long term, we have no idea who this is going to serve. The ramifications are, I'm reminded of a quote by John F. Kennedy, who was a supporter of the Electoral College, and he said, look, this is a solar system of governmental power, and if you change one aspect of the solar system, then everything else changes too, okay? If you change the gravitational pull of the sun, then you pull the Earth out of orbit, you change its atmosphere, maybe we would not even be able to breathe the air. We don't know. And so I don't like to make it into a partisan thing. Look, blue states have adopted it. I do think there are a lot of Democrats that support it, but I don't think the Electoral College is a partisan institution. I don't like to make it one. I think it serves us. I don't think we know who will benefit if it's gone, except that I'm pretty sure all of us will be really, really sorry.
Next question.
Derek Muller, Pepperdine University School of Law. You know, Dr. Koza, and the book title is Every Vote Equal and treating votes equally, but that presumes voters, and voters are determined as eligible by state. And over the history of our country, some states have allowed minorities to vote and others haven't. Some allowed women to vote and others haven't. Some reduced the voting age before others, and we've solved those by constitutional amendment. But now if you're a felon in prison in Vermont or Maine, you're eligible to vote, whereas in Alabama or Florida, you're not allowed to vote ever once you've committed a felony. And how can we say we have a truly national vote total when voter qualifications differ from state to state? And one day the state of California might decide to reduce the voting age to 16 because it suddenly means that it can influence a national election much more once we pool all of those votes together.
Well, we have that now. The state of Florida doesn't allow previously incarcerated felons to vote. Ohio does. They're both battleground states, and both of them have determined the outcome of presidential elections. So picture a state where the only voters were previously incarcerated ex-felons. The fact is that electoral vote total from the election-deciding state of Ohio is going to determine who's president under the current system. So we commingle and add together votes that come from voters who have somewhat different qualifications under the current system. And yes, that would happen under this system. But the wheels have not fallen off the ship of state, to use a funny metaphor. The fact is we have a federal system. One of its very good features is that politicians who often like to change election laws in advantageous ways. For example, Minnesota has extremely generous early and absentee voting, and in fact, same-day registration, whereas some red states have exactly the opposite situation. The genius of the federal system and differences is that no one political party ever gets to control the whole system. That's why federal election rules are not good. That's why the Constitution left those matters to the states. Not because the states are brilliant or more moral or clever or nice, but simply because no one political faction, as they used the term at the time, or no one political party would ever get the upper hand nationally. If we had federal control of elections, the sitting president with a toting Congress could rewrite the rules for the next presidential election. And that's the big thing the founders wanted to avoid, which is the recreation of a monarchy. That's why Article 2 does not let Congress review state decisions on presidential electors.
And I think Tara wanted to respond to that as well.
Look, this is a really important part of this, and this is something that NPV tries to blow by all the time, but let's just be very clear about what is going on here. We are currently in a system where there are 51 different elections, different election pools. In Texas, I'm in an election pool with other Texans. We are conducting an election among Texans to determine who will represent Texas, period. We're not affecting anybody else in the entire country. If Texas wants to vote Democrat one year, it will. If it wants to vote Republican one year, it will. It's voted both ways historically. It will do whatever it wants, but we are only affecting ourselves and Texas representation. Now, what they are changing to is they are changing to a world in which you have these 51 different elections, and then you pretend like it's possible to come up with one coherent result. They blend everybody into one election pool. Okay, so again, 51 elections, 51 results. Their system, 51 elections, one result. That is the whole big difference in a nutshell, okay? And now suddenly it does matter because a vote cast in Massachusetts might affect how my vote in Texas, like what happens with that, how Texas decides to award its electors. That all of a sudden it does blend together. An equal protection suit that is not possible now because all that matters is that Texas treats me fairly with other Texans, suddenly it does become an issue because now Massachusetts is treating me unequally with what Texas is doing, and it becomes, by the way, really confusing about, that's why I was mentioned venue before and all this stuff, like what do you even do? Now I will say, the precedents are really unclear. I mean, they're right, the Equal Protections Clause says within its own jurisdiction, but the question will be, can states combine together to do what they could not do by themselves? And that's what a court will decide, and I can't tell you what the court will decide. But I will just note for the record that for a group that claims that all they care about is democracy and making sure that every single vote is equal, you know, it's really weird to create a situation where you have one election pool and 51 different sets of rules.
Just press you a little bit. I know you want to respond, and I'm going to press you on the same topic, which is I think the questioner was pressing you even a little further than perhaps the answer indicates, which is if I'm California or I'm Massachusetts and it's a blue state, and if I'm Texas and I'm a red state, you know, I want to lower the voting age to 10 so that, you know, parents can tell their kids go out and vote for whoever they want to vote for themselves. And I love my 12-year-old, but I don't think he's ready to vote in a presidential election. So my question for you is, and it kind of goes along with this, is what do we do? Because the key is that I think the questioner is saying it actually creates incentives to change the laws that aren't present before the adoption of the National Popular Vote Plan.
Let me just briefly comment on these apocalyptic scenarios having to do with adding together votes. In 1969, the House passed by a 5-1 margin a constitutional amendment that got bogged down in the Senate. And it didn't establish federal control of elections or uniformity on any of these matters. It simply took the fact that we are a federal system that virtually every member of Congress supports. That bill was endorsed by Nixon, by George Herbert Walker Bush. Later, the same bill was endorsed by Carter and Dole and Mondale, et cetera. There is nothing incompatible with adding together the votes of the 50 states to produce a result. That's what that constitutional amendment did. It got bogged down in the Senate because of all the desires to, reverse the voting rights situation back in the 60s. But the fact is, a federal system is completely compatible with adding up votes. I can't answer your 12-year-old vote problem. I don't think that's a practical problem. I guess if it was, then I would call your attention to the real advantages of the National Popular Vote Plan to the defective 1969 approach endorsed 5-1 in the U.S. House. Namely, we're an interstate compact, and if it's really as horrible, and all these apocalyptic scenarios are going to come jumping out of the woodwork just because we elect the candidate with the most votes to office, then it's relatively easier to make adjustments and repeal an interstate compact that it's in effect due to state action than to try to unwind a constitutional amendment.
Thank you. Let's go on to the next question.
My name is Maya Nerona. I'm a Georgetown Law graduate, and when I was in 7th grade, I read an article in Discover magazine called Math Against Tyranny, and that convinced me of the wisdom of the Electoral College. What it said was, if I can summarize, the winner of the World Series is not the team that bats in the most runs. It's the team that wins the most games. And that, and we don't question the legitimacy of the team. You might have a fluke and win a game, but you didn't really deserve it. But the one who wins the most games in the series is the legitimate winner of the World Series. And that's why, if it's good enough for America's pastime, shouldn't it be good enough for America's president?
I love
Well,
that.
don't forget football, golf, basketball.
Look, I love that analogy, and it's just because it's so easy to understand. And the reason the World Series is run that way is because you want to encourage teams to be well-rounded, okay? You don't want a team to be the champion just because they have a really great pitcher or a hitter that does really well in a particular kind of circumstance. You want to reward the most well-rounded team, the overall champion, and that's exactly what we do at the Electoral College. I love that. Thank you.
Next question.
Peter Galey, Canisius College, Buffalo, New York. I mentioned that for one very important reason. If you're a member, a citizen in New York, and you are not of the Democratic Party, your vote simply is tossed away. Now, I'm not so anxious to get the Electoral College completely revised, but it does seem to me to make sense to have a proposal that allow for proportional voting among the states. That would not destroy the system, not create some of the horrors that have been paraded before us today, but it would, I think, deal with that one problem of sitting around watching the world go by as our vote simply means very little.
I want to respond to this.
Sure. Dr. Baker.
I would encourage you to move to support such a move in New York, and if the numbers are as suggested over here in terms of popular dissatisfaction with the Electoral College, maybe you can convince people on a bipartisan basis to do that.
Well, no, the issue I think you're raising is not whether we can convince people to do it. I'm asking you to give me a reason why we shouldn't do it.
Well, first of all, in argument, the advocate of change has to give the reason for the change. I've given the reasons for the current system already. There are different ways that individual states can do it. If you want to do it that way in New York, that's fine. I might add that had Romney won the popular election, I can't imagine that New York, which has already adopted the MPV, that the majority of people in New York would be very happy casting their electoral votes for Romney.
I guess it was. I think two possible reasons not to do it. Look, I'm just an advocate of every state decide what makes sense for you. I really don't care. Maine and Nebraska already do it. If it came up in Texas, my home state, where I think I would say something, I would encourage them not to. The reason I would say no, there's two simple reasons. One is gerrymandering. I like lines that cannot be controlled by an incumbent class of officials. Congressional district lines can be. If you're talking about the congressional district system. If you're talking about proportional, that becomes a math problem. Do you round up? Do you round down? Maybe 100 votes more would let you do one way or the other, and then you end up in a lawsuit about those 100 votes because I wanted to round up and now we're rounding down. And that's why I don't like proportional. So congressional. Okay, well, so but you have in New York you have 29 electors, so you can't award a part of a person. You have to award whole individuals without a constitutional amendment. So whoever that last individual is, you have to decide. Math examples on the fly are not my strong suit, but you have to decide which way that person goes. You know, the 51% is not going to come out perfectly. You're going to have to round. Is the long and short of it.
Yeah, that's
I'm
not.
sorry.
Look.
It's a lawsuit, is what it is, because because
You're-
some person's going to say, look, 100 more votes this way, and this elector that was Romney's is now Obama's, or you know, it'll turn into something like that. It's
You
just my
currently
opinion. It's
have
New
the
York,
right
you
to
should
do
what you
that
wanna-
in New York. The question is, why should New York's view dominate the other states?
Any other responses? Let's move on to the next question.
Good afternoon, and thank you for your presentation. My name is Dan Hind. I'm a trial judge, a state trial judge in Texas, so welcome, Tara. I want to look at this more perhaps in a historical and existential point of view.
Not a speech.
The Athenians did not directly elect their head of state. The Romans did not directly elect their head of state. The Venetians did not directly elect their head of state. And each of those republics lasted several centuries. The English do not elect their head of state. They've been in their same system for about 500 years. I'm trying to think of any democracies that did directly elect their state that did not implode and lasted or endured as long as any of those states, or as a matter of fact, the United States under the Electoral College system. Can you give me any examples where this has worked for as long as it's worked here in America?
This
No,
sounds
I mean,
like
I think-
oh, go ahead.
Oh, yeah, go for
I
it.
was going to say, Dr. Koza, this sounds like it was mostly directed at you.
We don't have that many democracies that have lasted 500 years. I can't give you an example, but that's not an argument as to why it wouldn't work.
Well,
It
can't we
certainly
look
worked-
at
it
Fourth
certainly
Republic
worked-
France or
certainly worked
Weimar
at the state
Germany?
level.
Did you want to respond too, Tara? Or?
I think that's the whole point. That's what the founders saw, and they saw that as a matter of history, pure democracies implode, and they didn't want to be that, but they wanted to be self-governing, so they were looking for something else.
Thank you. Next question.
Hi, I'm John Shea. I'm from New York. Thank you for a very, very interesting panel. I'd like to ask sort of the same question as the gentleman 2 questions before me, but I'd like to ask it actually as a question. And my apologies to the questioner. From what I've seen of the panel so far, Dr. Koza has outlined some of the problems of the Electoral College system currently. And Dr. Baker and Ms. Ross have outlined the problems with his proposed solution as well as some of the virtues of the current system. What I don't think I've heard yet, with the exception of the example from Dr. Baker of a possible district split, is much discussion of whether Ms. Ross and Dr. Baker, you acknowledge the problems with the current system, and if so, have any suggestions or ideas as to possible solutions for it. In your opinion, is there any solution, Dr. Koza's or otherwise, that is not worse than the disease?
Well, one, I don't think there's a problem to begin with. Insofar as for instance, congressional district proposal that I mentioned, which I don't support, the problem that was mentioned by Tara about gerrymandering, if you want to find the cause of that problem, it's Congress in the 1920s, because up till 1920, there was a statutory requirement that all congressional districts be compact. We haven't had that for almost 100 years. The point is that whenever you talk about anything, and I think Tara mentioned this and used a quote, our constitutional system is very intricate, and when you change one thing here, it affects other things elsewhere, and typically people don't contemplate the consequences. You know, as the framers said over and over again, they based their judgments on experience, not primarily on theory. And you can critique the current system in terms of pure democracy. But the framers rejected that for good reason. And that's the system we have. And if enough people don't support it, yeah, we won't have it.
I don't have many big problems with the system. I think most of the dissatisfaction comes from two things. One is a lack of understanding of the history and why we have it. I think that cures a lot. I think that there is a changed mindset in America to some degree. I think that people value their individual prerogatives more than was at the founding. I think at the founding they would have looked at it and said, look, we're not trying to create an election system that makes one person in one state in one election year feel really good about their vote. You know, that was not their goal. It just wasn't. Their goal was to create a healthy political dynamic for the new country they were creating. They wanted to serve generations of voters. They didn't want to serve one person in one moment in time. They just didn't care. And I think we still have a great, excellent system. Are there momentary personal frustrations sometimes? Sure. Look, I have my share of them too. It's not like none of us are exempt from this. But at the end of the day, we have a system that has served us successfully for more than 2 centuries, and it will continue to do it if we let it.
We have time for one short question, and then quick answers as well.
Sure, I will keep it brief. My name is Michael Hannon. I have a question that zooms out a little bit from this issue, but I think it's sufficiently related to this, and I think this panel would be very expert on the topic. I'm curious less about how we tally the votes we cast, and more about what the casting of those votes looks like. I know in Britain and in Australia there's been a lot of heated debate, and in some places in Australia quite recently, about the difference between kind of a first-past-the-post system of voting and what's called the alternative vote, or different forms of alternative vote, where you don't just pick one candidate, that's where you throw all your chips, but you have kind of a ranking system for various candidates. There's various ways that you can structure this, but that there seem to be some pitfalls with first-past-the-post that might avoid, maybe by ushering in some of its own. But I was curious, has anything like that ever really come to the forefront of the conversation in America? And do you think that there are any significant relationships between that and the current question about the relationship between the Electoral College and the way we elect our presidents?
Anyone have a quick response?
If you're on a law faculty or any faculty, you quickly learn about the dangers of so-called strategic voting and prioritization, and that's a long discussion. But the other point is that what the founders wanted to do was to create stability. And every time somebody comes up with a problem and they think we got to change things because we got a problem, they create the really big problem, instability.
I think I would just say real quick, I think that it probably leads to the same problems as a runoff system. Just because if you give voters, you're basically giving them second chance to vote, right? They're doing it all at once because they're ranking individual or whatever it is, but you're basically giving them multiple chances to vote. And anytime you do that, you undermine the two-party system, which somebody asked this is a frustration I know some people have, but I would just suggest that our strong, stable two-party system is a lot better than the alternative, the multi-party fractured state of affairs that you see in European governments sometimes.
Thank you.
All right, that concludes our program, but I hope you will join me in giving a round of applause to our panelists. Thank you.